Thank you for joining us and welcome to our Labor, Employment, and Human Rights webinar on Canada's newly introduced immigration policy and the impacts on employers. My name is Daniel Lee, and I'm a partner at Fasken based in Vancouver. My practice is focused on Canadian immigration law. I work closely with clients on corporate immigration matters, employment immigration compliance, and global mobility for employers. Before we begin, I would like to mention about our survey and CPD certificate options. QR codes and links will be available at the end of our session to fill in our survey and to obtain your Ontario or Quebec CPD certificate or your Ontario HRPA certificate. We will also include Law Society of BC information for those of you who are called to the BC bar. If you miss the QR code or the links, certificate will be sent to you next week. I also want to touch point on a few things. First is the handout. The presentation materials can be downloaded through the handout tab. And the closed captioning, to turn on the closed captioning, please click on the CC button under the radio window. And we will also have a survey. So it's under the survey tab, so you can complete the survey at the end of the presentation. If you have any questions, you can type in your questions to the speaker into the question tab. And finally, if there are any technical issues or require any technical support, you can click on the tech support button at the bottom of the video window page. Next. So we'll try to be a little bit more engaging and fun today. So what we'll do is we'll do a couple of posts throughout the presentation. So when the post slide appears, what you need to do is to click on the voting button, which is on the right-hand side of the radio window in the join the chat bar. And in this case, you would select one answer to the response. Once you selected the answer, the response would immediately turn blue. So let's try one to test it out to see if it works or not. So the question we have today is what day is it? So I'm glad that you all selected Tuesday. Maybe some of you would prefer a different day, maybe Friday. So thank you for testing that out. So we'll move on to the presentation for today, and we have a lot of really interesting topics to talk about in terms of changes on the immigration policy. So the first part of today's agenda would be on Canada's new immigration policy. So we'll cover 5 major topics. The first one is spousal open work permit, followed by flag polling and express entry. And then fourth is policy impacting international students. And then finally, any changes on labor market impact assessment. After we introduce the changes in immigration policy, we will provide you with some information on what are the potential impacts on employers. And we'll also talk about what are some of the frequent asked questions from employers. We'll go over 5 of them. And we'll finish off today with our Q&A session. So we have about 20 minutes or so allocated for the Q&A. Next. Before we dive into our first topic on spousal open work permit, I have a couple of messages that I want to share with you. And these are concerns that we're seeing from our corporate clients. One of them is we want to help our employees to extend their work permit, and we're also willing to obtain a labor market impact assessment or LMA for them. So just because the employer wants to help them obtain an LMA work permit, there's no guarantee that they can obtain one because there are certain employer-specific requirements that must be met. Secondly, not everyone in Canada would be able to transition for permanent residency due to the current cap and restrictions in applying for permanent residency. And we'll touch base about this a little bit more later in our presentation. And third is a little bit hard for employers and foreign nationals to accept, and that is some foreign nationals who are currently in Canada on a study permit or a work permit may have to leave Canada when their immigration document expire because of limited pathway for them to extend their work permit or to apply for permanent residency. Next. So our first topic today is on spousal open work permit. Next. So recently there has been some changes in terms of eligibility for spousal open work permit for anyone who are accompanying their spouse in Canada. So previously, if you're traveling to Canada, your spouse is in school, that could be any bachelor program or master program, PhD program, the accompanying spouse or common law partner would be eligible to apply for a spousal open work permit. But with the new changes, in order for the accompanying spouse or common law partner to apply for a spousal open work permit, their spouse must either be in Canada studying at a master program, and that master program has to be at least 16 months in duration. Or their spouse is in Canada studying a PhD program. It also applies to some professional and eligible bachelor programs. So that could be like Bachelor of Nursing, Education, Engineering. It also includes a number of professional programs such as like MD, medical school, or Juris Doctor law degrees. Turning to spousal open work permit, for those who are accompanying their spouse in Canada as foreign workers. Previously, when you accompany your spouse in Canada, regardless of their occupation, one would be able to apply for a spousal open work permit even for a lower skill occupation. But recently, the restrictions apply, and the principal applicant in Canada would need to be employed in a high skill occupation. So in Canada, all the occupations are divided into a tier category system. Tier 0, 1, 2, 3, 4, and 5. 4 and 5 has historically been classified as low skill occupation, and usually you cannot use that to apply for permanent residency under express entry. Whereas any occupation in tier category 0 to 3 would be eligible to apply for permanent residency under express entry. So tier 0 or 4 managerial position, and tier 1 occupations or for professional occupations. Tier 2 and 3 occupations usually require some post-secondary education. So moving forward, the principal applicant would need to be employed in a tier 0 or 1 occupation or eligible in tier category 2 or 3 occupations based on the labor search linked to the government's priority. So the occupation for the tier category 2 or 3 would change from time to time. So if the current occupation is listed, it doesn't mean it will be listed indefinitely. In addition, previously, dependent children who are in Canada and their parents are in Canada on a work permit, they would be eligible to apply for open work permit. This eligibility has now been removed. Next. So some of the key takeaway is in the future, the pool of foreign nationals in Canada with open work permit will be more limited due to the higher eligibility requirement to apply for a spousal open work permit. And then if you have any existing employees who are in Canada on an employer-specific work permit, for example, let's say you're an international company, you transfer one of your employees from overseas, such as Brazil, to work in Canada. This person is currently employed in a tier 2 or tier 3 occupation, and their spouse is in Canada on an open work permit. So because right now, their spouse would not be eligible to extend their open work permit. So some of these employees may choose to leave Canada and return back to the home country if they're unable to obtain permanent residency. And then there are like existing employees on open work permit. For example, like they receive the open work permit through their parents, they would not be able to renew those. One example of this could be like if you hire a lot of youth in retail or in the food industry, then you may need to be mindful that you need to have a plan in place to replace these existing employees. Next. We move on to flagpoling. Next slide. And flagpoling is no longer permitted right now. So let me explain to you what flagpoling is. So in the past, before December 24th, a foreign national in Canada who has a valid status in Canada may choose to make a day trip to the US. And after they return from the US to Canada, they would be able to apply for a new work permit on the spot, and the border officer would make a decision on the same day. The reason why a lot of foreign nationals prefer to apply for a work permit or an immigration document at the port of entry is because the officer will make the decision on the same day. And if they are required to make the same application within Canada, it would take 3 to 4 months. So for them, it's just a really quick way to obtain their work permit. For example, let's say you have an employee where you want to promote them into a new role. Under normal circumstances, they would need to receive their new work permit before they can work in their new role. And it's hard to tell the employer that this person cannot start until 3 or 4 months later. So in the past, with flagpoling, the person can instantly change their position or employment location by having a new work permit. Right now, there are some individuals who may still be eligible to apply at the port of entry. So this would apply to U.S. citizen or U.S. permanent residents. So this prohibition of the flagpoling does not apply to U.S. citizen and permanent residents. I also want to touch base on that sometime you would have employees who are currently in Canada. For example, they might be on a post-graduation work permit or on a working holiday work permit, and they have applied for a new work permit, such as under the International Experience Canada program, where it consists of both the working holiday category and also the young professional category. And those work permit applications were considered as outside of Canada applications, so they don't benefit from maintained status. And once their work permit application is approved, they would need to travel outside Canada and return to Canada and get the border officer to issue their new work permit to them at the port of entry. So in the past, a lot of people would simply make a trip to the U.S., come back, get the border officer to issue the new work permit. But now they would need to travel to a different country. They're no longer able to travel to the U.S. And upon the return request for the new work permit to be issued to them. This would be a cost consideration for a lot of foreign national. Next slide, please. One thing that I want to draw to your attention is like the current processing time for work permit extension application within Canada. It's up to 4 months, and that processing time is subject to change. So it could take longer or it could take a little shorter. So because of flagpoling is generally not allowed for many foreign national, the work permit extension application should be submitted as early as possible, and we recommend to start on the work permit extension application as early as 6 months. So this way, it would prevent the employee in entering into a situation where they would not be able to renew their driver license or their provincial health care. And then, secondly, I want to address the situation where if the foreign workers is in Canada with a non-worker status, so for example, they may be in Canada as a visitor, because as a visitor, you're not allowed to apply for a work permit from within Canada. And once they have their work permit application approved, they are required to leave Canada. As I indicated to you earlier, they're no longer able to travel to the U.S. and they need to travel to somewhere else. Even if they travel to the U.S., they stay for 2 days or longer. There has been some inconsistency from border officer to interpret whether or not that is considered as flagpoling, and whether or not they have left Canada. So because of the potential risk involved in being classified as flagpoling, the best practice is to travel to another country for at least 48 hours, excluding the U.S. Next slide. Okay, so we'll turn on to express entry. I'll get the next slide, please. Okay. What you have in front of you right now is the immigration level plan for 2025 to 2027. And for this year, the quota to apply for permanent residency has been substantially reduced to 395,000. And this is a reduction of about 150,000 from the previous year. Initially, like the projected number of quota for 2025 was supposed to be 545,000. If you take a look at some of the data, what we have right now is we have over 125,000 people who have created an express entry profile. And sorry, my apology. I want to indicate that, like, by taking a look at this chart, the number of allocation for express entry. So what we have here is like the federal economic priority and also the in-Canada focus. Both of these are for express entry. Number is approximately 125,000. And currently we have 237,000 foreign national who have created an online express entry profile. So that means there are close to 2 times as many people who want to immigrate under express entry than the quota for this year. This means the likelihood for many of them being selected to apply for permanent residency is reduced. So not every one of them will be able to apply for permanent residency. Later in this presentation, I'll talk about provincial nominee program, but I also want to draw to your attention that there was an annual quota for the provincial nominee program for outside of Quebec, and that's only 55,000. And many of the programs across Canada for each province, their quota has been reduced by 50%. We'll move on to the next slide. What we have in this slide is like the total number of foreign nationals who have created express entry profile. And this gives you a little bit of information in regards to the CRS score range for most of the people. A lot of them falls under the 401 and 450 points range. And there's close to 62,000 of them. So those who have more than 500 points, that adds up to close to 26,000. So that just means like the points required in the future would continue to be relatively high. If you take a look at the information on your right side on the slide, there has been more rounds of invitations to apply specifically for French language proficiency. And most recently, on March 21st, the points required for French language proficiency rounds of invitation to apply was reduced to 379 points. And then previously, it was about 410 or 428. So for anyone who do not have French language proficiency and they need to rely on the Canadian experience class, they have to get at least 521 points. The points does fluctuate from time to time, but it is still in the 500s. Next slide. In case some of you do not have experience with Express Entry is a case management system. So under Express Entry, there are 3 different federal immigration programs. The most common one is called the Canadian Experience Class. This requires someone to have at least 1 year of full-time paid work experience in a tier 0 to 3 occupation. So when you have an employee who contacts you, they want to apply under Express Entry, but they work in a low-skill occupation, they would not be eligible under the Canadian Experience Class. There's also the Federal Skilled Worker Program, and that looks at foreign work experience instead of Canadian work experience, just in case if you have employees who are recently transferred to Canada from overseas and they have not worked in Canada for 1 year yet. And finally, there's a Federal Skills Trades Program, and these are generally for occupations in construction, transportation, manufacturing, and natural resources. So what happened is a foreign national would need to first meet the basic eligibility requirement for one of the federal programs. Subsequently, they would create an online Express Entry profile, and points would be allocated to them based on their age, their education, the work experience, and a number of other factors, including do they have any siblings in Canada who are Canadian citizens or permanent resident. So from time to time, the government would have draws, and candidates with the highest points would receive an invitation to apply for permanent residency. So currently, there are 3 different types of rounds of invitation to apply. The first one is called general rounds of invitation. So that means if there's a invitation for 3,000 or 4,000 people, those who has the highest points would receive an invitation. It includes anyone who meets one of the above mentioned federal programs. There's also program-specific draws, and this is where it may be for the Canadian Experience Class, or it may be for the Federal Skilled Worker Program or Federal Skills Trades Program. Category-based draws is when they focus on the category that's been selected for this year. The types of category selected for each year is subject to change, and it changes every year. So one example of category-based round of invitation includes French language proficiency or STEM occupations. And I'll go through the other ones in a few moments. Next slide. In 2025, for this year, the government's focus would be helping those who are currently in Canada to transition for permanent residency. So many of the rounds of invitation would be focusing on the Canadian Experience Class. So there's going to be a lot of invitations specifically for the CEC. In addition, the federal government has an emphasis in promoting more French-speaking individuals from outside of Quebec. So there's going to be more invitation to apply based on language proficiency in French. And then there's going to also be a focus on certain types of occupation. The first one is in healthcare and social service occupation. So think about family physicians, nurse practitioners, dentists, pharmacists. and also chiropractors. Secondly, there's going to be trades occupations, so carpenters, plumbers, contractors. And there's a new one that was added recently, and that's the education occupation. This includes teachers, childcare educators, and instructors of persons with disability. Last year, there were also different categories, and these categories are still available. They include STEM occupation and also agriculture and agri-food occupations. Next slide. So the Canadian government, when I prepared the PowerPoint slide, I did it last week. So this slide should actually be updated because this morning there has been some announcement that for express entry, arranged employment points are no longer available. What arranged employment points is, when you go through express entry, and if you can get your employer to help you obtain a labor market impact assessment, LMIA, what an LMIA is, your employer would usually need to advertise the job for 4 weeks and demonstrate that there are no Canadian citizen or permanent residents qualified for that position. Subsequently, you would submit the LMIA application to Service Canada. Service Canada would make a decision to determine, is it true that you can't find someone in Canada qualified to work in that job. If the LMIA application is approved, you would receive a LMIA approval letter. The foreign worker or foreign national can take that LMIA approval letter to apply for a work permit. So that's what Labor Market Impact Assessment, or LMIA, is. So in the last few years, there has been some unethical individuals or stakeholders who take advantage of the current immigration system, and they would sell LMIA approval letters to foreign nationals who are desperate to immigrate. So in order to prevent this from happening, last year, the government announced that arranged employment points would be removed. So this removal of arranged employment points applies to both one, LMIA work permit, and those who have employer-specific work permit, who receive a job offer from their current employer to apply for permanent residency, and they have worked for their current employer for at least 1 year. Next slide. So a couple takeaway for you. The first takeaway is employers would need to reassess their current hiring practice, and would need to also consider whether or not they need to rely less on hiring temporary foreign workers and international students, because the pathway for them to apply for permanent residency is now reduced, and also to apply for a work permit for them, such as obtaining a LMIA work permit, will be more difficult, and I'll explain to you why it will be more difficult shortly. Secondly, employer are receiving more requests from employees to help them apply for LMIA work permit before March 25th, or to support them in their provincial nomination application. The reason for that is express entry is quite hard for them to receive an invitation to apply. So what they need to do is to explore alternative options. And those options include obtaining permanent residency through a provincial nomination program. And then before today, they were previously able to obtain additional points under express entry for arranged employment between 50 and 200 points. So this is no longer permitted. I want to also share that employers are not required or obligated to help their employee to apply for a work permit or to apply for permanent residency. And it's really important to assess it on a case-by-case basis, because if you help one employee, you may have to help other employees. And if you have a large number of foreign workers in your workplace, that could be problematic because you won't be able to support everyone. Next slide. So I was going to do a poll, and you guys are actually really smart. So the question is, like, when you hire international students, like, what documents do you request from them? So I'll give you like a moment, and then we'll switch over to the next section in which talk about international students. So this is kind of this will give you like an idea of like your knowledge level on this topic, because this is one of the most common questions that I get every day from my clients on or these international students authorized to work in Canada. If yes, what are documents required from them? So I'll just give you like maybe 5 seconds before we move on to the topic. I feel like there are a few people who are switching between the number 2 and number 3. All right, so we'll move on to the next topic and just kind of end the poll for now, or in like maybe 2 seconds. So, okay, awesome. I think I have a really smart class of attendee today. The answer to that is actually the fourth one, which is you have to request them for a copy of their SIN, work permit or study permit document, and also proof of their enrollment in school. Next slide. Okay. So a couple of things I want to talk about for international students. One is like how many hours are they allowed to work off campus? Secondly, what are the new requirements to apply for a post-graduation work permit? So let's talk about the first topic first. Last year, in November, the government increased the number of hours international students on valid study permit or on study permit where they can work off campus. So it has increased from 20 hours per week to 24 hours per week while they're in school full time. And if they are on their scheduled academic break, they're allowed to work full time. And full time is not defined, so it's not capped at 40 hours, for example. So they can work as many hours as they want during their scheduled academic break. Be mindful that not all international students would have scheduled academic breaks. There are certain programs that are presumed that they're in school full time for the whole year. For example, like PhD programs or any master program that is research based. Secondly, turning to like post-graduation work permit. Before like November 1st, when clients come to me, they say, I'm going to hire someone who's an international student in Canada. This is their last semester. It used to be really easy because if they have studied full time, they comply with the conditions of their study permit. Then after they receive their completion letter, they can submit their post-graduation work permit application. And once that application is submitted, then the government would provide an acknowledgement received letter. You show that acknowledgement received letter to your employer. That is proof for the individual to work in Canada full-time until they receive a decision on their postgraduate work permit application. But they always make it really hard for lawyers and for people who work in HR. And that is, since last year, April 1st, not all international students would be eligible for a postgraduate work permit. In the past, we simply look at, are they studying at a designated learning institution that offers postgraduate work permit eligible programs. Now, that's only the starting point. We have to dive in a little bit deeper and also ask, when did they submit their work permit application? Was it before November 1st, 2024 or after? If it was before, then those who are not studying at a university, but maybe at a college, they would be able to still apply for a postgraduate work permit regardless of which program they study, as long as they also meet the language requirement. But for anyone who apply for a study permit after November 1st, if they study at the college level, they would have to study at a program that would make them eligible to apply for a postgraduate work permit. And that has to be in a field linked to occupation in demand in Canada. But for anyone who study at a university at a bachelor, master, or PhD program, they will continue to be eligible to apply for a postgraduate work permit. There is the additional requirement that they have to be able to obtain a minimum language proficiency in French or English, which is at a CLB level 7. And for those who study at a college, it will be CLB level 5. One thing to be mindful of is if there's a foreign national who's studying at a university, but it's not a bachelor or master or PhD program, then they won't be eligible to apply for a postgraduate work permit. So just be aware of that. Next slide. Okay. So this is kind of like what I have as a checklist. When you hire international students, these are certain things that you need to find out. First, there could be some international students who travel to Canada before the program starts. Let's say the program starts in September, they come in late July to settle in. They are technically not authorized to work in Canada until after they have started their program in Canada. So that's why you can't just ask them for a copy of their study permit and they're sent. Instead, you also need to obtain a copy of their confirmation of enrollment letter and also their transcript, which indicate how many courses they're enrolled in for the current semester. So these are things that you need to find out through these documents. One is, are they currently studying full time? So this is where you can obtain a confirmation by looking at how many courses they're enrolled in. And for some confirmation of enrollment letter, the school would also indicate that they're currently studying full time. And if that's not the case, then you would need to also review the transcript. Secondly, is they have to be enrolled in a post-secondary academic, vocational, or professional training program. And on the work permit on the bottom, there has to be a notation confirming that they're allowed to work in Canada, either on campus or off campus. It refers to that R186FV and W. So you need to ensure that wording is there, because not all study permit would have that wording in situations where they may be in Canada for a language course, and then if they're only in Canada for a language course, then they won't be authorized to work in Canada during their studies. And then fourth, they have to have commenced their program of study. So the confirmation enrollment letter would give you that information. And they also need to provide you with their social insurance number. Next slide. I apologize. This is kind of a bit of a repeat. I want to have this slide for you. So when you hire employees who are international students, to just make sure that you ask them for a copy of their transcript and the confirmation or enrollment letter to ensure that they're currently studying full time. And it's also best practice to ask them for these updated documents at the beginning of each semesters, because they're only allowed to continue to work in Canada if they're still in school full time, except for their last semester where they're permitted to work part time. sorry, except for the last semester where they're permitted to study part-time. Sometime they may be on a scheduled academic break, for example, winter break or summer break. And in those cases, you would require to obtain a letter from school confirming that they're currently on a scheduled academic break. Next slide. Okay, so the employer takeaway. First, it's becoming more difficult to be qualified to apply for a post graduation work permit because of the additional language proficiency. So if you're planning to hire someone for a role to start after they finish their study, there could be potential delay. So you need to be mindful of that. And sometimes you may need to educate the candidate that there's a language proficiency requirement because the language test is only valid for 2 years. And if they have taken the English test before they commence their program of studying in Canada, there's a possibility that that test may not be recognized because you would have to complete like a proof test from Immigration Canada. And usually when you apply to enroll into school in Canada, you would need to complete the academic version and not the general version. And then the final thing that I want to, I think like that summarized that pretty well for that section. So I'll just keep the slide for you for your reference. And then next slide. Okay, this is the fun part because I think a lot of people are getting inquiries about labor market impact assessment. Next slide. So what I would do today first is I'll just explain some basic concept about labor market impact assessment so we can ensure that everyone understand what LMIA is before we talk about some of the recent changes in LMIA. So in Canada, there are different work permit categories, but there are 2 immigration programs. So all the different work permit categories fall under one of these 2 programs. The first program is called the Temporary Foreign Worker Program, which require a labor market impact assessment. A lot of employers would prefer not to go through the Temporary Foreign Worker Program because the process to obtain an LMIA could be quite onerous on the employer. Secondly is the International Mobility Program, which is exempt from the LMIA requirement. So one example of this is like a global company transferring their employees from the US to work in Canada. So that's called like intercompany transfer. Under most circumstances, like the employer should try to find a LMIA exempt category. And if there is not one available, then the last option is to apply for a LMIA if the employer meet all the requirements. So as I mentioned earlier, generally speaking, like there is a requirement that you need to advertise the position for 4 weeks and demonstrate that there's no one in Canada who Canadian citizen or permanent residents qualify for that position. And when you advertise the position, there's certain requirements such as like what is the salary range for that position, language requirement required for this role. Is it French? Is it English? Or is it both? You're not allowed to require for a non-official language. For example, let's say Smash. The other thing for LMIA application is like there is a requirement to pay the individual the prevailing wage, and the prevailing wage is determined by what is the national occupation classification code for that position and the employment location. Furthermore, the employer needs to demonstrate that their business and the job offer are both legitimate. Next slide. So first I'll talk about some of the changes for the LMIA highway stream. So for LMIA, there are different streams. Most commonly, there's a high wage and low wage, and when you need to decide to use a high wage or a low wage stream, it's actually determined by the province, um, the provincial median wage. So in this case, if you want to use the high wage category where you can obtain an LMIA for 3 years instead of 1 year, because for the LMA low wage, the LMIA work permit is only issued for 1 year, then for Ontario, you would have to pay the employee at least $34.07, in addition to paying the prevailing wage for that NOC coal as well. Quebec will be $32.96. BC is $34.62, and for Alberta, it's $35.40. And this is a 40%. This is a 20% increase from previously in November 2024. So not a lot of employers would be able to meet this requirement, and this means they may not want to support with the LMA low wage, because the LMA low wage also has some requirements that doesn't apply to the high wage, and that includes paying for the employees like transportation to Canada and return to the home country, and also ensuring that they have affordable accommodation. So for a city such as Vancouver, where I'm currently living, to ensure that they have affordable accommodation that does not exceed 30% of their compensation could be challenging. Next slide. The changes to the LMA just never stop. So for LMA, there's the low wage stream. So since September 26, ESDC no longer process these type of application if the census metropolitan area has an unemployment rate that is 6% or higher. So that means for certain places, such as like Toronto, Montreal, and Calgary, they were unable to apply for an LMA. So there are a few exceptions to this, and that includes like jobs related to food security sectors. Next slide. And similarly, for Montreal and Laval, they're also not processing LMA low wage applications right now, and this temporary pause will be until November 30th of this year. Next slide. There are also some new documents requirement for LMA applications for all the streams, and that is the Canadian governments are no longer accepting like attestation letter. So in the past, like accountants and lawyers would be able to prove business legitimacy by confirming that they're in good standing, but now more honest documents are required, and that includes, for example, like business license, T2 schedules. For some startup companies, it would be more difficult for them to be able to have their LMA application approved because they're unable to provide these documents until after they have at least been in operation for a year. Next. The processing time for LMA has been increasing in the last year or so, and sometime employees would be required to submit concurrent LMA applications and work permit extension application because they have not received a decision on their LMA application. Please note that Immigration Canada only hold in making a decision on the work permit extension application for up to 60 days. So if they cannot receive the LMA approval letter by this timeline, then there's a risk that the work permit extension application would be made and there could be a refusal. This would impact the employee's ability to continue to work in Canada. Next. Okay. So a few takeaways. One is just because the employer wants to help their employee to apply for an LMA, it may not be possible because the employer may not meet all the eligibility requirement. For anyone who's in Canada on an LMIA work permit and they no longer meet the provincial median wage, it's important to assess alternative options for them to apply for a new work permit or to apply for permanent residency. And for LMIA work permit, employers are subject to receiving random immigration inspection, and you need to be aware that there are certain restrictions. For example, if you want to promote someone to a new role or change their employment location or increase their salary more than 2%, you may need to obtain a new LMA work permit before you can do so. Next slide. So what we'll do right now is we have about 20 minutes left for this component before we move on to the Q&A. So we'll talk about the most common questions asked by employers in recent months. So we'll turn on to the first question. The first question is what can the employer ask during an interview? The recommendation is keep it to, are you legally authorized to work in Canada? Because each province have different laws for human rights. For example, in BC, citizenship is not a protected ground. So therefore, in BC, we're allowed to ask someone, do you have an open work permit, or when does your work permit expire? But in Ontario, that is not permitted. So the recommendation is work with an employment lawyer to determine the permitted questions for each province and territory that you operate in. Next slide. So takeaway is, as I said earlier, work with an employment lawyer, figure out what you're allowed to ask, depending on where your business is operated. And then secondly, before the employee starts their job, after you provide a job offer for them, there is a requirement for you to ask them for a copy of their work permit and also their social insurance number. Next. So we got one final poll question, and that is, in 2025, what's your company strategy regarding hiring temporary foreign workers? So it sounds like many of you are considering, at least a quarter of you are considering hiring less temporary foreign workers due to uncertainty in immigration law, and then some of you are remaining relatively the same number as last year. And there's also a quarter of you who are not too sure. So we'll give it maybe 5 seconds. So 5, 4, 3, 2, 1. It's very interesting results. I think rather than not, you'd be hiring foreign workers really depends on the industry you're in, and it's not like a light switch where you instantly not going to rely on foreign workers. It probably require a transition plan depending on directions you're heading. So I'll move on to the second question. Okay, I get this question every day, which is, I have employees, their work permit is expiring. What are the options? And the answer that you will hear from a lawyer is it really depends, right? So if they're in Canada on an open work permit right now, there's no guarantee that they can renew the current work permit because some work permit cannot be extended. For example, a post-graduation work permit for international graduates, those who are in Canada on a working holiday work permit. So for instance, if you're from Japan, you can only participate in that working holiday work permit one time in your lifetime. And then For other employees on open work permit, maybe their spouse is in Canada on a work permit or on a study permit. So rather or not that could be extended depends on if the principal applicant is eligible to extend. And for anyone who are on a employer-specific work permit, so if an employee is in Canada on a LMIA work permit, then you can't just submit a new one for them. You have to obtain a new approval for the LMIA. So that means you need to factor in the potential timeline, and you should start this process at least 6 to 8 months in advance. Secondly, for those who are in Canada on LMIA exempt work permit, for instance, intercompany transfer work permit, there could be a cap in terms of how long they're allowed to be in Canada for. Next. Generally speaking, these are some of the options for people to apply for a new work permit. If you're in Canada as a student, you may be from a country such as the UK, Australia, where there's an agreement with Canada, so you can apply for a working holiday or young professional work permit under the International Experience Canada program. If you speak French or are able to develop French proficiency, the Francophone Mobility Program, if the job is located outside Quebec. In some cases, for like senior or executive level position, we can do significant benefit without obtaining a LMIA, prove to the government that we need this person to be in Canada because it would create either significant economic, cultural, or social benefits. And then reciprocal employment. Imagine like an international company who has a global mobility policy. If there are Canadians who have opportunities to work abroad, then you can rely on this to help someone to work in Canada, even if they're not an existing employee. Finally, there are various temporary public policy, for example, for those in Ukraine or from Iran, where they can apply for open work permit. Next slide. So a couple takeaways. Not all employees have the same options to apply for permit, to apply for a new work permit. Some of them may have very limited or no option available. Employers are not required to assist any employee with LMIA application. And then finally, even if someone is in Canada on a work permit, there's no guarantee that there's going to be a pathway for them to obtain permanent residency. I'll move on to the next slide on question 3 on maintained status. So maintained status used to be called implied status, and it was changed a few years ago. Although the terminology is different, the concept is the same. What it really means is if you have an employee who has a work permit that is about to expire and they have submitted a work permit extension application from inside Canada before the current work permit expiry date, they would be authorized to continue working in Canada until they receive a decision on their work permit extension application. Subject to they do not leave Canada after their current work permit expire. If they do so, then they will not be able to work in Canada on maintained status until after the work permit extension application is approved. So it could be a case where there's a student on a study permit, they apply for a postgraduate work permit. And then in those cases, once they submitted their postgraduate work permit application, they would also have maintained status to work in Canada. Unlike foreign workers, international students are able to leave Canada, and it doesn't affect their ability to continue to work in Canada until they receive a decision on their post-graduation work permit. Hopefully that helps for the distinction. Next slide. Oh, can I, one more slide. Okay. When employees submitted their extension application for work permit, the government would provide a form for them. That form would say, you're currently authorized to work in Canada on maintained status under 186U of the regulation. And then there's also like a date. That date is provided there based on the current expected processing time of that work permit extension application. It doesn't override um, Regulation 1A6U. So even if the letter is like outdated, they can still contain a working count until they receive a decision on their extension application. But it will be recommended for the employer to obtain additional proof that their application is still pending. That could be asking them to submit a IRCC web form confirming that your application is still pending, or asking them to log onto their IRCC portal to show you that their application is still pending. A decision has not been made yet. Next slide. So a couple of takeaways. I'll just highlight the essential ones, which is when you have an employment agreement with foreign workers, it's important to have a work authorization cost saying that the job offer is conditioned to having and maintaining a work authorization to work in Canada. If not, then the employment ends based on frustration of contract. Secondly, we've been noticing that there are more international students who extend their current post-graduation work permit. The post-graduation work permit is only issued for up to 3 years once in a person's lifetime. So technically, they're not allowed to extend their postgraduate work permit unless it was issued not for the full duration due to passport expiry. But a lot of them take advantage of the maintain status provision and submit their extension application. So employer needs to be mindful that just because they submit their extension application, there's no guarantee it will be approved. So it's good practice to have it in writing to your employee that it's their responsibility to check their status on a regular basis. If their application is not approved, to immediately notify HR and to stop working Canada immediately. Next slide. So this is kind of like the question that I get asked about: should I help an employee with an LMA application or provincial NAMI program such as OIMP or BCPMP? And this really depends on the employee's situation. So before today, with LMIA, you would be able to receive additional 50 points or 200 points based on the occupation, but this is no longer the case. So previously, what you could have done was to ask the employee, what is your current express entry score? And then if they can likely receive an invitation to apply with additional 50 points, then you may want to consider supporting them, assuming all the other eligibility requirements are being met. You would usually bypass LMA and go directly to PMP, like when you know the additional 50 points or 200 points would not be sufficient enough. The advantage of the provincial NAMI program is it's a direct pathway to apply for permanent residency once you receive a provincial nomination from the province. But many of the province has a point-based system. So that's why there's no guarantee that they will also obtain permanent residency, because it's very competitive now. So the takeaway here is you don't have the obligation to help them with either LMA or PMP. And if you choose to do so, it's important for you to consult with a lawyer to find out what are the potential legal risks involved. For instance, like for PMP such as like OIMP, when you assist an employee, you have to ensure that all the information are truthful. There's no misrepresentation, and if there's like any potential issues with that, then the non-compliance could be listed on the Ontario government's website. There could be a potential ban using OIMP for up to 5 years, and also monetary fines. So you need to be mindful of that. Move on to the next slide. So this is like our last question. last like popular question for today before we switch over to the Q&A session. The question we have here is, there's a increased frequency of employees asking for support under PMP, and that's because express entry is becoming more difficult. So if we move on to the next slide, I just want to focus on the takeaway and give you a little bit more time to ask any questions that you may have. The takeaway here is, before you decide rather not to help an employee with the PMP application, you need to first find out, have they already received an invitation to apply, or they're just asking if we can support them. Because if they have not received an invitation to apply, then it may be a better practice to ask for them to contact us once they do, because there's no guarantee that they would receive an invitation to apply. So when they receive an invitation to apply, before providing them with like any of the forms required from the provincial government, we need to ensure that the employer meets both the job offer and employer's requirement, because if you don't, that application will likely lead to a refusal, and it doesn't help anyone. So I hope this helps like for the top 5 questions. So we move forward to the Q&A session now. Thank you. So feel free to take a moment to type out like any questions that you may have, and then I'll get Andrea to read them out one at a time. I'll try my best to answer them.
Thanks, Daniel. We have a number of questions that have come in throughout the presentation. So I'll start off with one of the big ones here is, are the rules for immigration changing because of the influx of immigrants, or is there another reason?
I think like part of the reason for the changes like in immigration policy is because like of like potential housing issues. Like the immigration ministry indicated that we're reviewing the right number for both permanent residents and temporary residents in Canada. And we want to also help those who are currently in Canada to transition to permanent residency before we open up the immigration for outsiders.
All right, great. Another one here. With the removal of the arranged employment points, will this impact executive applicants that do not require the LMIA, et cetera?
So right now, so previously for executives, they would be able to have 200 points if they work in a double zero knock occupation. And that means they don't need to obtain a labor market impact assessment. Most of the time, like they're in Canada on an LMA, except work permits such as intercompany transfer or a significant benefit application. So they would probably have the biggest impact because they're usually a little bit older, even though they have high language proficiency and education, but they're not favorable in terms of the points like for the age. So in a case like this, where they be losing up to 200 points, it's best to take a look at, are there like any alternate pathways for them to apply for permanent residency, such as using a provincial nominee program, because they will probably be a stronger candidate there, since many of the provinces don't have like a points allocation for age, at least for Ontario and BC.
Great, thank you. Another one here is that it seems counterintuitive that the LMIA won't be processing when employment is low. Do you know why that's a new rule?
I think like what they try to do is to focus on giving job opportunities for those who are currently in Canada as Canadian citizens, permanent residents, or those who have work authorization. So if there's a particular area that has an unemployment rate that is higher than 6%, I think there's some justification there for not processing any low wage LMA application, but this does not prevent the employer in supporting a high wage LMA application, but you have to ensure that you meet the provincial median wage. So, sorry, I just want to highlight one thing, if you give me a moment. If you take a look at like the figures required for Ontario, Quebec, it's actually quite high because Ontario's like you have to make sure you pay someone $34.07. So not a lot of employees will be able to use the LMA high wage, and they're forced to use the low wage. But low wage are giving you restriction now in terms of submitting the application when the unemployment in that area exceeds 6%. So they're telling you that we're not really that immigration friendly, and that's why it's important to find out like are there like any other options available, such as like is this a global company where you can do reciprocal employment work permit, or is this someone between the age of 18 or 35 where they may be able to apply for a working holiday work permit. So moving forward, companies needs to be a little bit more innovative with the immigration solutions.
Great, thank you. And this next question pertains to the announcement today, so I appreciate if this is just a general comment. But do we anticipate that the LMIA PR stream will be removed, and does it have any value outside of the previous points it offered?
That's a difficult question, actually. So I can't predict like what will happen to the LMA PR stream. Just for context, like for those who do not do a lot of LMA in the past, previously a lot of employers would prefer the LMA PR stream because there's no requirement to do a transition plan. But now, like even for the LMA PR stream, like the transition plan still imposed, and also you have to either meet the requirement of the LMA low wage or high wage stream. So it does feel like the LMA PR stream is quite it doesn't serve its purpose as before. So there could be a possibility that it may be removed completely in the future, but I can't predict that.
Great, thank you. Another one here. If an employee's work permit expires while they are on maternity leave, are there any protections for that employee, or what happens with them?
So you're referring to a context where like someone has a valid work permit and then they went on mat leave, and subsequently their work permit expired during mat leave.
Correct.
Is this question like referring from a human right perspective or from an immigration law perspective? Because I focus my practice on immigration law, so I probably can't touch on a human right component. But from an immigration law perspective, like in order for that person to continue to have legal authorization to work or be able to come back, they would need to provide proof that they're able to obtain a new work permit or be able to go and maintain status. So that question's a little bit technical. If the person who does have that question, feel free to contact me privately, and then I can connect you to an employment colleague who could give you the answer to that question directly.
Great, thank you. Another one here. What's currently happening with TN1 visa requests at the border with CUSMA (NAFTA) issues?
Okay, so like I think the question is in relation to like Canadians wanting to apply for a U.S. visa to work in the U.S. So the TN is referring to professional occupations. So Canadians who are lawyers, accountants, engineers, are able to apply for this U.S.-Mexico-Canada agreement work permit. It used to be called NAFTA. You can still make the application, but recently, like there has been a lot of bad experience from Canadians at the border. They're taking more time for these visa application, or when you're traveling to the U.S., they would ask you more questions to ensure that you're truly entering the U.S. as a business visitor for a business meeting, and there has been a few people from Germany, Canada that has been like wrongfully detained. So you can still apply for the work visa, but it's recommended for you to apply at a U.S. pre-clearance center. So that means apply at one of the international airports in Canada. So that would be Ottawa, Toronto, Paris, and Montreal, Trudeau, Vancouver Airport. So this way, if there's any issue with your application, you won't be detained. You can just withdraw from your application. Whereas if you apply at the land border, you're fiscally on U.S. soil, so you could technically be detained. So before deciding to make an application for the work visa, it's best to probably speak to a immigration lawyer before you travel, due to this topic has so much changes recently.
Great, thank you. Lots of questions coming in today. Another one here is, are there any consequences for the company if the employee does not get accepted to the Ontario Provincial Nominee Program?
Are there like any consequences on the employer if they don't get accepted? So how it works is like, it's an expression of interest. So the employee will first create an OIMP profile and wait for an invitation to apply based on their points. There's no guarantee that they would receive an invitation to apply. And currently, the Ontario government has only issued like one invitation so far in the last 3 months because the quota has been reduced. So the real question for the employer is, before you decide to support them, you have to figure out which stream they're using, and does the employee meet the employer requirement, the job offer requirement, and does the employee themselves meet the applicant's requirement? If not, then that application will likely not be approved, and it doesn't help the employer because submitting an OIMP application doesn't give the employee any legal authorization to continue to work in Canada if their work permit is about to expire.
Great, thank you. Another one here. Is there a way for the employer to know if the work permit extension is approved? And a secondary part to that question is, how long does the employer have to wait before terminating the employee if they don't provide us with the appropriate documentation?
Sure. So the decision on the work permit extension application is usually communicated to the employee directly, and Immigration Canada would send an email notifying them that there's a message or a document on their portal, so they need to log in to check. So that's why earlier I recommended that you should write an email to the employee confirming that it's their responsibility to check their application regularly and to also notify you of the decision, because there is no way for the employer to find out the decision unless it's being notified by the employee himself directly. So we know that the current processing time right now for work permit extension application is 4 months. So it's best practice for the HR department to put it on the calendar, 4 months, checking with the employee what's their status, and then from there on, either checking with the employee every 2 weeks or once a month to ensure that the application is still pending and it hasn't been refused yet, because employers are obligated to ensure that employees have work authorization. If not, there could be a monetary penalty of up to $50,000 or potential imprisonment for up to 2 years. So you have to be really careful with that. In terms of like termination, that really is like fact specific. You do have to speak to the immigration lawyer to find out in this particular circumstances, depending on if they're in a unit environment or not. Rather than not, you can move forward with the termination, and a copy of the employment agreement would also be required. Andrew, do we have any final questions before we conclude for today?
We do, yeah. Do have a couple more here.
Sure.
So if an employee applies for a new study permit or a new work permit the same day as their old permit expires, are they eligible to continue working?
You gotta be really careful for that one because the time zone that they use is actually um, London, UK time zone. So it's not actually the local time zone where they're based at. If they submit the study permit or work permit extension application before the current permit, work permit or study permit expire, then they would have maintained status. But just make sure that you're aware of it's London, UK time and not local time.
Right. And this question was from a bit earlier in the session here. So someone wants to confirm if the PGWP and to other visa no longer qualifies for maintained status.
Sorry, Andrew, do you mind just repeating that question one more time?
Yep.
Sorry.
The viewer writes, so just to confirm, the PGWP to other visa no longer qualifies for maintained status.
That question's not worded completely. I think like you're referring to a situation where someone's in Canada on a post-graduation work permit. Their postgraduate work permit is about to expire. Under normal circumstances, they're not allowed or they're not qualified to apply for a second post-graduation work permit for international students, but many of them would do so because they want to rely on the maintained status. Legally, if they submit a second work permit application or extension application before the current postgraduate work permit, they can rely on maintained status. What I wanted to draw to the audience attention is like in these cases, the application will likely be refused because you can only have one postgraduate work permit in your lifetime. So that's why HR or employers needs to be mindful and have the right expectation that it may be refused, and you need to check in with them more regularly to make sure that they have not already received a decision that's negative and continue working in Canada illegally. I hope that kind of answered the question.
Thank you. So we do have another one here.
Sure.
Can you increase your wage to $34 an hour to be eligible for high wage LMIA, even if that exceeds the prevailing wage for the occupation?
So there are two requirements for LMIA high wage application. One is you have to meet the provincial median wage. So let's say in this case, $34 or so for Ontario, and then you also have to meet the prevailing wage for that position in the employment location. So if that a prevailing wage for the knock-in employment location is less than $34, you still have to at least pay that person $34.
Right. Thank you. Let's see here. And are benefits considered in determining the prevailing wage requirement as well?
No, you're not allowed to include any benefits or any like bonus. It has to be like guarantee compensation amount. So such as like if you get housing, that's also not included. So just the base salary.
Okay, great. And just one last one here. So with implied status pending a decision, how would an employer know if they weren't approved if the employee doesn't share the denial letter?
So that's a really great question. So like when someone apply for their work permit extension application, they will typically receive acknowledgement received letter, and some of them also receive a letter confirming that you have maintained status. That second letter is not guaranteed. So what most employers would do is they'll find out on the government website what's the current processing time for the extension application. So let's say 4 months. So they put in the calendar 4 months, check in with the employee, say, please provide proof that you have your application is still pending, or for example. And then if they cannot provide you proof of that, then you may need to look into potential termination. Usually, employers would say, let's have a team meeting or let's have a meeting. You log onto your IRCC portal, show me that your application is still pending. Most employees will be willing to do so because they want to continue to work in Canada. The best case scenario is like they submit like a IRCC web form and then ask them for the status of their current application, and then the immigration officer will say like your application is still in process. Like that would be the recommended, but there are different options.
Great. And sorry, one last one that just came in here that I think might apply to a lot of folks is we have an employee that has confirmation that their status is under review. Can they continue working until a decision has been made?
Under review simply means like your application is currently pending. So they would be able to rely on maintained status subject to two things. One is the work permit extension application was submitted before the current work permit expired, and they didn't leave Canada after their work permit expiry date.
Great. Thank you so much.
Those are some really good questions. Sorry that the presentation is not in person, so I couldn't see. It'd be nice to see some of your reactions for the two questions that we had for the poll. I just want to conclude today's presentation and thanking you in attending today. You will see information on your screen for credits for Ontario, Quebec, and BC. The links are also added to the audience chat, so feel free to claim your CPD for that. And also, like our next LEHR's webinar will be on Wednesday, April 16th. So keep your eye out for the invitation in your email inbox. And if you want to attend any other Fasken events, you can visit our website under the events section of fasken.com. So once again, thank you so much for joining us today. Wishing you a wonderful day. Thank you.